Okay, Mr. Church, are you ready on Mr. Schlapp's case?
I am, Your Honor.
Mr. Schlapp, if you want to come forward, please. This is file number 236568, 6569, 6570, and 6571. Records should reflect defendants present here in the courtroom today. If I can have counsel put your appearances on.
Good morning, Your Honor. For the record, my brother, people.
Thank you, Your Honor. Richard Trushpring on behalf of Mr. Schlapp.
And Mr. Trush, how did we want to proceed in these files today?
Thank you, Your Honor. This is the date and time for a probation violation hearing. I had an opportunity to speak to Ms. Davis last week on that, her request, and we would be joining in that. She'd like to monitor the file a little bit longer. So we'd ask to adjourn it out, and I'll defer to her as to the length of the needed term.
Ms. Davis?
Yeah, yes, Your Honor. He's doing very well with Child Protective Services in that case, maintaining negative drug screens, attending counseling, all of the programming that's expected. So I would like to adjourn it out maybe another 90 days, and then at that time, I possibly will dismiss this probation violation.
All right, Mr. Schlapp, have you had a chance to talk to Mr. Trush about this?
Yes, I agree with everything that's being said here.
I just want to make sure that you understand that you have the right to have these resolved sooner than that. But you also have the choice to proceed as Ms. Davis is suggesting. So just want to make sure you understand what your options are. Have you been able to discuss that, Mr. Trush?
Yes, I understand. Yeah.
And you want to adjourn this out?
Yes, Your Honor.
Okay, so we'll do that as Ms. Davis has suggested. The court will set it for another hearing in about 90 days. Ms. Davis, for some reason, we don't need to proceed further. Just notify us.
Yeah.
Take that down. Mr. Schlapp, just make sure that you stay in touch with Ms. Davis.
Yeah.
Thank you.
Thank you, Your Honor.
It's like,
I did end up wanting to look at it.
oh, no, that's okay. As long as you have them.
Yes, sir. So, sentencing.
Okay. I did confirm this morning.
Oh,
Yes.
And just to remind the court, Mr. Bussel, I think he's not.
Mr. Karsten, are you able to hear me okay? I'm sorry.
Yes.
Okay. 1 second. And just for the record, because apparently the computer did not click on the first case with Mr. Schlaff. If court reporters looking for transcript of Mr. Schlaff's proceeding, it is just prior to the case we're discussing now. Now we're on the record in People versus Kyle Karsten, file number 246756. The record should reflect that Mr. Karsten is present by video from the Otsego County Jail. We have both counsel present here in the courtroom today. Got a number of matters up for hearing on Mr. Karsten's case. First of all is the final status conference. We do have trial set to begin on April 28th. This would be the plea cutoff date, so I just want to address that first. Mr. Trush, have you had a chance to go over any plea offers with Mr. Karsten?
We discussed what would be an acceptable agreement to him. I've had discussions with the prosecutor about that. At least at this time, we're going to be proceeding forward to the trial.
Okay, so Mr. Karsten, you understand that today is the final hearing before your trial date. So if you wanted to enter into a plea, this is the cutoff for that. So this would be the last opportunity to do that. Do you understand that?
I understand that.
And have you had an opportunity to go through any plea offers with Mr. Trush, your attorney?
Yes, I have.
And is it your wish to proceed to trial in this case?
Yes, sir, it is.
Okay, all right, very good. So the court will order that the trial proceed as scheduled to begin on April 28th. Then we have this set for a hearing on Mr. Rolla has filed a notice to introduce evidence of some prior bad acts, both under 404B and the domestic violence statute. Mr. Trush, you filed an objection to that. I did have an opportunity to review your objection as well as initial notice. So Mr. Trush, any oral argument that you wanted to present today?
And very briefly. So I'm going to start with I'll start with the domestic violence, and then I'll talk about the forgery, because I think they are different while similar issues. So in regards to the domestic violence, I think there's a couple important things for the court to consider. The first of which is the court, I think, should consider and take note of what the disposition of the cases are. This is a situation where the domestic violence was charged. It was charged. Defense was ready to proceed and defend the case. Frankly, there at least appears to be a fairly viable self-defense claim there. Obviously, in this case, no trial ever happened. The prosecutor voluntarily dismissed the charges. I believe the Nali Proseque indicated that it was at the request of the victim or after consultation with the victim. It was something in regards to that. I would indicate to the court, obviously, the court's well aware, and we go through this, it feels like ad nauseum, but the victim doesn't control what happens with charges in the state of Michigan. They're not empowered that way. The prosecutor is. But I think it's important for the court to consider the disposition of the case there. This is a case that Mr. Karsten wasn't given an opportunity to defend because the prosecutor voluntarily chose to dismiss it. And I think necessarily that creates an issue of confusion at a subsequent trial for a jury, because what winds up happening is we have a trial within a trial, because the prosecutor is going to raise this issue. We're going to have to meet that by essentially raising the same defense that we would raise in a trial. And now we get into this convoluted issue of a trial within a trial. So I think that there's an issue there. In addition to that, I would point the court to look at the case of People versus Heath. This is a 2002 Michigan Supreme Court case. Unfortunately, it does not have a site yet. It's just blank, 2002 case. But I think that is probably the most relevant thing to consider here. What that case stands for is the premise that other acts evidence isn't logically relevant to a case when the underlying act is undisputed. And what that means is to bring in other acts evidence to show this history of violence in a case where it is undisputed. undisputed that my client shot Lee Karsten. To bring in other acts evidence isn't relevant. We know what happened here. We know. I mean, it's been stipulated to, Your Honor signed a stipulation to bring in all the lab evidence to support that. It's undisputed who shot who there. So under People versus Heath, I don't think that this evidence would pass the relevancy test in that circumstance. Moving on to the forgery claim, which again is similar but a little bit different. The forgery claim, again, I'm going to ask the court to really take into account and look at the disposition of that case. What we have here in the forgery claim is a case that went to preliminary exam approximately a month or so ago. At the preliminary exam, it was dismissed for lack of probable cause. Judge Hesseling found that there was not evidence presented by the prosecutor to support that my client was the person who committed the crime, who did the thing. Now, I understand the prosecutor intends to and may have already refiled under a different theory. I consulted with the jail over the weekend to confirm Mr. Carson has not been arraigned on that. There's no date set on that. So as it stands right now, the disposition of that case is it was dismissed to the preliminary exam for lack of probable cause. I think it flies in the face of what we do to suggest that the prosecutor should be able to bring in other acts that are not found to be reliable, that lack probable cause to get past a preliminary exam and assert those to the jury as if they're true proven facts when they're not. It flies in the face of everything that we're doing. They're simply not reliable. That's in addition to the same arguments as far as just confusion to the jurors. Because again, we're going to have this situation where we're now talking about that trial within a trial. We're going to have to start bringing up questions about who signed checks, who authorized what, who cashed checks, which again detracts from the real issue here. It seems weird to say this in a case that's set for a 5-day murder trial, but frankly, the crux of this case is actually very simple. Kyle Karsten shot Lee Karsten. Was that shooting justified? I mean, that's it. That's the case. That's the question the jury is going to have to answer. Does this help the jury to find that at all? And I think the answer is no. Additionally, the same arguments under People versus Heath are going to apply here, which is to say, again, the prosecutor wants to bring this in to bolster or support the motive for the alleged crime. But how could motive evidence be relevant when, again, we know who the person who did the thing is? No question. No question there. Again, I know under the analysis here, the court can, have the defense sort of outline their theory of the case, so to speak. I don't think it's a mystery to the prosecutor. Our theory of the defense here is it's going to be self-defense, and we're going to argue about why this happened, not what happened. So again, I think it fails the relevancy test as well as not meeting the criteria under 404B.
All right, thank you. Mr. Rolla.
Your Honor, with all due respect to defense counsel, our legislature passed this domestic violence statute. It has been repeatedly upheld, numerous decisions, including, by the way, even the one cited by defense counsel. The difference, of course, the argument the defense is trying to make is that, well, it doesn't pass the relevancy test. It's, with all due respect to our courts, as our appellate courts have said, this isn't a situation where it's up to the judge to decide that. Our legislature has decided this is admissible, except only one circumstance where it's not, and that's where there's an acquittal. This is not an acquittal situation. Now, as far as the forgery, that it might be an entirely different situation, but the people's position is the domestic violence is admissible. The legislature has said so, it comes in. And more importantly, in this particular case, we have a situation where if the court looks at the language of the dismissal, it doesn't just say that this was done at the request of the victim, which, by the way, defense counsel also is incorrect on the law, because domestic violence is the only statute in the state of Michigan where the victim in a domestic violence can ask that the prosecution not proceed. It's that way, and that language is contained under the Michigan Crime Victims' Rights Act. So they do have an ability to make that decision. Further, in this particular case, the dismissal in this case, as the defense counsel is very well aware, was not just at the request of the victim, but the reason for the request of the victim, not because it didn't happen, but because the mother of the victim was threatening to file for divorce if the victim didn't agree to have this dismissed against the charges against her son. This goes directly to motive because, in fact, in the prior domestic violence case, the defendant made certain statements about actions he would take against the defendant. And also one thing to correct, as the people understand it, unless the defense is going to do something different now in trial, we've not received a notice of self-defense. What we've received is a notice of supposedly battered child syndrome, which is not a self-defense case, which is not a specific self-defense, for which there's a separate definition, for which there's a separate jury instruction, for which there's separate things that the jury has to be told. For all of those reasons, Your Honor, it's relevant as to motive, it's relative as to intent, it's relative as to prior actions, schemes. It's also, our legislature has specifically said that this shall come in except where there's an acquittal situation, and our appellate courts have repeatedly upheld that. Their motion should be denied.
Your objection, Mr. Truchet, if you wanted to say in response.
I guess, Your Honor, what I would indicate to the court here, and at least insofar as a domestic violence, which seems to be where the crux of the prosecutor's argument is, there's probably somewhat of a distinction without a difference. And I say that because I stand by the arguments I've made. I don't think that it comes in as case in chief. I do think that it probably is going to be admissible for rebuttal purposes. And I say that because the rules of evidence indicate in a homicide situation, we can bring in prior violent acts by the decedent. And then in response to that, the prosecutor can rebut those by bringing in prior acts from the defendant. I think that's a situation we're going to find ourselves in, but I think that's the only situation in which that becomes admissible and relevant. And again, I have to say it's likely a distinction without a difference, because I think that that's, I imagine that's the track that the trial is going to follow, but I don't know that for sure. I don't know what evidence is going to be presented until I see what the prosecutor's case completely looks like. And I won't know that till probably day 3 or 4 of the trial. But I stand by those arguments. I don't think it comes in as case in chief. I don't think it's admissible for those purposes given these circumstances.
All right, thank you. Again, I did have a chance to review the file prior to the hearing today. Had a chance to review the written submissions by the parties, as well as the documentary evidence, the police reports and so forth, prior incidents that were submitted as part of the written submissions. So I'm well versed in the facts, the evidence that the prosecutor is going to seek to introduce here. There's 2 different provisions that would allow the admission of each of these different types of evidence. So I want to go through the standards on each of those for the record here. But first, I want to note, as I do in all of these kind of motions, that whether or not to admit evidence is a matter that's within the discretion of the court. The court is acting within its discretion in making that ruling today. The court notes that generally the rules of evidence are rules of inclusion, not rules of exclusion, and that's a general proposition. The court, looking at evidence that might be admitted under MRE 404B, prior bad acts, the court has to find, first of all, that it's being offered for a proper purpose. And in this case, under 404B, I find that the issue of the prior accusations of forgery would fall under 404B. First of all, the court has to find that it's being offered for a proper purpose. The prosecutor has to articulate a non-propensity reason. In other words, reason for the evidence to be relevant, other than that it tends to show that the defendant is a bad person or commits bad acts. If there is a proper purpose, then the prosecution has to show that it's relevant, that it's logically connected to some matter that's at issue, material issue in the case. In this case, the prosecutor has put forth, I think, primarily the purpose of motive in this case. In other words, that the defendant had a reason to commit an assault or a murder on the victim in this case. And that is that the victim believed that the defendant had committed a forgery, had stolen some money, and was threatening at various points to go to the police and turn the defendant in. And that was a motive for the entire situation involving the defendant and the victim. And how it devolved from the period of time in late 2023 and early 2024 up until summer of 2024, when the murder took place. And so the court finds that it is a proper purpose. It's being offered to show a nexus or a connection between the defendant's actions in this case and a reason for committing those actions, other than that the defendant is just a bad person or commits bad acts. And so I do find that there's a proper purpose, and I do find that it's logically connected. Outside of that, the court then has to determine whether or not, even if it is logically relevant to a proper purpose, whether it should be excluded under MRE 403 because it's unduly prejudicial, or that it would confuse the jury, or that it would result in something like a trial within a trial, as has been suggested by Mr. Truch. In this case, I find that it would not require that, first of all, a trial within a trial. Second, I find that rather than confusing a jury, in my view, this is going to give a jury a much broader picture of the relations between the defendant and the victim in this case, and is likely going to allow the jury, in my view, to make a more reasoned decision if the jury understands the whole course of conduct that led up to the final incident. And I think this forgery incident is part and parcel of that, based on my understanding of the facts. So under a 403 analysis, the court finds that it's not unduly prejudicial and that it's not going to result in confusion of the issues. I also believe, though, that the defendant should be entitled to a limiting instruction, both at the time that the evidence is offered and in the final instructions, to instruct the jury that they're only allowed to consider that evidence for the reasons of either background information or as a motive or a reason that the defendant had to commit the crime in this case, and that they can't find the defendant guilty just because they believe he may have committed a prior bad act. So the court will allow the admission of the evidence with the limiting instruction as to the forgery issue. Regarding the domestic violence evidence that the prosecutor is seeking to admit under MCL 768.27B, that statute allows a more expansive admission of evidence. The court can admit it for reasons, as I've indicated, under MRE 404B, but the statute specifically allows the court to admit that evidence for any reason for which it would be relevant, including propensity. So the court can admit that evidence in circumstances where it wouldn't be appropriate under MRE 404B, and that's because the legislature has determined that incidents of domestic violence, like sexual assaults against minors, is a particular kind of crime that makes the defendant's propensity to commit that kind of crime more relevant than other types of bad acts. The court still has to conduct an MRE 403 balancing test if it does find that it's relevant and admissible under 768.27B. In this case, again, the court finds that this crime did not occur in a vacuum. I think particularly relevant, and I understand, Mr. Truch, your position that this evidence may be admissible on rebuttal depending on the defense put forward. But as you indicated, parties have already agreed ahead of time. The court signed a stipulation that the forensic evidence is going to be admissible, and that the issue here really isn't going to be whether the defendant committed the shooting in this case. I think your argument that this would be admissible until rebuttal might be more convincing if the defense was going to be that the defendant didn't commit the shooting in this case, but it doesn't sound like that's what it's going to be. And so I don't find that to be a reason not to allow it in the case in chief. Also, Again, as I indicated with the forgery evidence, this crime did not occur in a vacuum. It occurred as part of a course of conduct between the defendant and the victim. If the defendant's defense is going to be self-defense, which it may or may not be, but if it is, the evidence regarding violence between the two of these individuals, I think, could be helpful in some ways to the defense. Certainly, it's relevant to the ultimate incident that ended in the victim's life being taken in this case, and whether or not there were prior instances of domestic violence between the two, and whether or not the defendant was the aggressor in those prior incidents, or whether the victim was, and whether the victim was the aggressor in the issue involving the crime in this case. I think those are all questions that the jury is going to have to determine. And I think that the prior incident is relevant to that. I think it's relevant for propensity purposes. If the jury determines that the defendant has a history of committing domestic violence against the victim, that's relevant to whether it occurred in this case that resulted in the victim's death. So I do think it's relevant. I think it's admissible under MCL 768.27B. I think, as with crimes involving sexual assaults on minors, I don't think there has to be prior charges regarding the prior incidents. There certainly doesn't have to be prior convictions for it to be admissible. There's ample case law which holds that those prior incidents are admissible if they're otherwise relevant, regardless of whether they've resulted in actual charges or convictions previously. So I don't find that to be a controlling factor here either. The 403 analysis, again, given my statements here, I believe the relevance of the prior incidents of domestic violence outweighs any prejudicial effect, given the course of conduct between the two parties. So the court finds that there isn't a 403 reason to exclude that evidence. However, again, as with the forgery evidence, I think it's important to instruct the jury on the uses of that evidence, and the court will provide a limiting instruction again at the time that it's introduced and during the final instructions. So that is the ruling of the court. Mr. Trush, or I'm sorry, Mr. Roloff, you can prepare an order that just reflects the reasons stated on the record.
Will do, Your Honor. And I would indicate for the record the proposed instructions prepared by the people included limiting instructions as already addressed by the court on the record.
Okay, thank you. Mr. Trush, are there any other matters that we need to address prior to the trial?
There are three things. One, I understand the court's ruling. I do want to make a brief record,
Sure.
if I may. I agree with the court's analysis insofar as the statutes don't require that charges be brought or that there's a conviction. I do think this is a distinctly different scenario in that in both of these situation charges were brought and ultimately dismissed. Again, I just want to make that distinction for the record. Secondly, does the court want me to prepare limiting instructions for both the domestic violence and the forgery issue?
I think since the prosecutor did, I'd be more than willing to see your draft of those, and then the court will have to make a ruling prior to giving those instructions.
And then in the same vein, did the court want to address issues with the jury instructions today as opposed to using time during the trial?
Do we have any issues with either the initial instructions or the preliminary instructions? If we just have issues with final instructions, I think I have to wait until after the proofs are in before I can make any rulings on those.
So that would include chapter 1 and chapter 2.
Right.
There are a handful that I identified.
Okay. Not prepared to address those today, but can you tell me which ones are the issue, and then are there any with chapter 1 instructions?
I would just indicate, I noted in chapter 1.1, I think the prosecutor included Judge Hunter.
If we're just talking about like typos, no, I will certainly clear those up. Are there any substantive issues with the chapter 1?
Correct, yeah, and I apologize, I've got the list of things that I was gonna go through. 1.8 and 2.4 have an issue. We submitted it as essentially an open murder instruction. The prosecutor submitted it as murder 1 and murder 2 in the alternative. I don't know how the court wants to rule. I mean, obviously, I prefer mine. I drafted it. I don't know if there's really a right or wrong answer to it.
On that note, Your Honor, there is specific standard criminal jury instructions for this exact situation, which is the ones that people use. Because again, it is to be charged in the alternative. In fact, this case law, we have to provide the court with it in that regard should it become necessary. But then not only in the instructions, but also in the verdict form, there was a specific instruction that the triers of fact can only come to one decision or the other. They can't find Mr. Carson guilty of both murder in the first degree as well as murder in the second degree. And that is under the open murder instruction as provided for and utilized by the people in their proposed jury instructions.
Okay, so 1.8, it's my practice and my view of the instructions that the court simply reads the information as it's been filed. So as to 1.8, I'm just going to read the information jury as written. The other instruction requires the court to give, the basic elements. And so as to that one, Mr. Trush, what is your suggestion? Since I don't have it in front of me.
So the way that I proposed, and I don't think there's a disagreement as to what the elements are. I propose it as the instruction to the jury would be murder in the first degree, murder in the second degree, and I also included voluntary manslaughter would be included as lesser included offenses. I think that gives the jury the opportunity to consider all of those, and that's how I would propose reading it.
Judge, I don't believe voluntary manslaughter can be included, so I don't think it's a lesser included instruction of murder in the first degree or second.
Well, okay, either way, I don't think it's appropriate as part of the chapter 2 instructions. I certainly would consider that as part of the final instructions. So I will read the elements to count 1 and 2 as part of the chapter 2 instructions.
Understood. In regards to 2.5, the prosecutor included the old instruction. There's a new instruction on what reasonable doubt is. And that's the only difference there.
Okay. I will read the most updated instruction.
The prosecutor after 2.5, he includes what I think should be in chapter 16. So he includes in there, I think that some of the specific instructions for murder 1. So I think he included maybe 16.1, 16.
Like some of the definitions.
Yes. I think those are more proper at the end.
Except, Your Honor, our Court of Appeals has ruled unless they're included, as Judge Hunter has repeatedly reminded me when I've forgotten to do it twice, unless they're included, in fact, at the time the original instructions are given, as well as the explanation to the jury after the information is given, that can in fact create an appellate issue because it is not advising the jury of all of the elements and definitions under the section by which the elements are otherwise defined. Which is why I included them where I did.
All right, I'm looking at the prosecutor's April 9th, 2025 submission. Oh no, these are your proposed instructions. Okay, sorry.
The prosecution's proposed jury instructions that are 4/16. Is that right?
April 6th.
Yeah.
People did
Okay.
submit an amended proposed jury instruction, which by the way corrected some of the deficiencies as referenced earlier by the defense counsel.
Okay. I'm gonna take some time to review these further. I have your objection noted, Mr. Trush, and I will make a determination on that. I think some of them may be appropriate, because the standard instructions do provide that the court should give, definitions of terms where appropriate. So some of these may be appropriate, but some of them in terms of, like the instruction on inferring the state of mind, I'm not sure that that's really a definition of a term that would help the jury understand the elements. So that may be more appropriate as a final instruction as opposed to that's an instruction at the time of 2.5. So I'll go through those and I will rule on those prior to reading them to the jury.
And then just one last one in the initial ones.
Okay.
Prosecutor included 2.17 publicity. I did not include that, but I would indicate in the time period between when I filed them and today's date, I did have local media reach out to me for statement. I obviously declined, but it would seem to me the publicity instructions probably relevant.
Okay.
And as our office has also been contacted on several occasions, that's why I included instruction.
Okay. All right. Anything else that we need, Mr. Trush, from your side prior to trial then?
I don't believe so. The prosecutor and I have been in good communication in terms of working through, I think, most of the issues.
Okay. The only other thing that I'll ask, the morning of trial, just because of the length of this trial and the number of potential witnesses and how things can change even up till the night before, if each of you can have an updated list of witnesses you intend to call for me to read to the jury, and if you can have that ready so that I can have that on the morning of trial.
And on that note, Judge, Mr. Trush and I, as indicated, very good communications. We've eliminated a few of the lab personnel pursuant to the court's ruling. We were just waiting for that order to come back signed for me to prepare an amended witness list.
Okay. Mr. Roll, anything else we need to address for your side?
Not from the people in this case. Thank you, Judge.
And Mr. Trush, have you made arrangements for Mr. Karsten to have appropriate clothing and so forth for his appearance in court?
We have. I don't know that they're at the jail yet, but we've taken measurements and we've made arrangements to get clothing procured.
Okay. And I will communicate with our corrections staff. As usual, we'll have the defendant, properly dressed. We'll have a way for him to be escorted so he comes in through the normal courtroom entrance so that he's not brought in any differently than anyone else for the jury. And any other procedures you'd like to request, just let me know in the morning of trial, Mr. Church.
Understood. Thank you.
All right, thank you. That's all for today. Mr. Carson, we're going to go ahead and disconnect at this time. All right, Mr. Musel, are you able to hear me okay?
Yes, I am, Your Honor.
All right, we'll go on the record in People versus Dustin Musel, case number 256829. The record should reflect Mr. Musel is present today by video, by prior approval of the court. If I can have counsel put your opinions on that.
Record, Judge, I'm going to people.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Musel. This is the date and time set for a jury status conference. I think our first one here on the circuit court. We're still engaged in negotiations with the prosecutor on this. I had sent the proposal out to Ms. Brooker, I think last week. I haven't got a response back from it yet. I would suggest to the court probably another 30 or so days would be appropriate. Again, I think we're closer than we are further away from an agreement here.
And Judge, in light of the notes I'm looking at our file and by Ms. Brooker entered on the 19th of March, I would have a tendency to agree with what Mr. Trush has indicated.
Okay, so Mr. Trush, again for the record, when are you asking the court to set this for the next hearing?
I would just suggest about 30 days, or I mean, if that day is already full, I wouldn't begrudge more time.
All right. One thing I did want to address, because Judge Hunter was originally assigned this case, he disqualified himself based on the defendant's relation to an employee here at Otsego County. I want to make a record of, I'm aware of that employee. I don't have any direct dealings with him. And I don't know him or the defendant personally. I've never really had any experience with the defendant at all. So I didn't find that there was a reason for me to disqualify from the case, but I want to make sure that Mr. Trush, first of all, you and your client are aware of that, correct?
I was aware that Judge Hunter had disqualified the reasoning behind it wasn't provided to me, but I was aware he had disqualified. I don't have any objection to Your Honor being in the case.
Okay, and I guess I didn't phrase my question well. You're aware of the relationship between the defendant, the employee, and the fact that the court deals with that employee.
Oh, absolutely.
Okay. All right. Mr. Rolla, people would likewise have an opportunity to ask for disqualification.
We're aware of the reasons that Judge Hunter recused himself. We see no reason for this court to have to do so. We have no objection to Your Honor being presiding judge over this matter.
Okay. All right. So I do find that there's a valid reason for adjourning the hearing out today. So we'll set this first hearing in about 30 days. Go forward at that time. Mr. Rolla, anything further that we need to address today?
Not in this case. Thank you, Judge.
Mr. Trush.
Your Honor, I do see Ms. Jans is logged in via Zoom. I know she had reached out to my office probably a little more than a week or so ago, had asked about addressing the no contact provision. I explained to her that Your Honor controls that. I don't have any ability to remove, modify, anything like that. But that if she wanted to address you, this was the appropriate venue to do it.
I'm going to leave that up to the prosecutor. If there's a motion to amend a bond condition by the prosecutor based on the wishes of Ms. Jan, she's the alleged victim in this case, or one of them, is that correct?
Correct, she's the alleged victim.
So Ms. Jans, to the extent that you want to have anything modified with regard to the bond in this case, I would encourage you to talk to the prosecutor's office, because a motion would need to be filed and the court would have to consider that, okay? All right, thank you. Mr. Musel, do you have any questions about how we're going to proceed with your case?
No, I do not, Your Honor.
Okay. All right, thank you. That's all on this file today. All parties on this case are free to disconnect at this time.
Have a good day.
People versus David Eaton, case number, Mr. Eaton here. Yep. Mr. Eaton, if you want to come up to the podium, please. It's file number 25-6824 and 6825. The record should reflect that the defendant Mr. Eaton is present here in the courtroom. If I can have counsel here.
For the record, Your Honor, my calling that
Thank you, Your Honor. Richard Trush, on behalf of Mr. Eaton.
Mr. Trush, can you tell me the status of these two files from the defense side today?
Yes, Your Honor. I think we do have an agreement in place where Mr. Eaton will plead to the first file, the second one will be dismissed.
So that's file 25-6824. And that's one count of possession of methamphetamine.
That is correct.
And in exchange for that, the charges in the other file would be dismissed.
Correct, and I believe that it's substantially the same.
Is that a correct statement that we offer, Mr. Rolla?
That's an accurate statement. Thank you.
Mr. Eaton, have you had a chance to talk to Mr. Trush about this plea agreement?
Yes, sir.
Okay. And is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God? Thank you. Mr. Eaton, are you currently on any kind of probation or parole?
I'm under stress.
Okay.
I'm required to remain at my residence, except for grocery shopping and Saturdays.
Outside of that, are you under any court's jurisdiction?
So just to be clear, the house arrest is part of your bond in this case, correct? In these matters? So you don't have anything else in court other than these two matters, right?
Yes, that's right.
All right, and Mr. Trush, did either of these offenses occur while he was on bond for the other, where there's a consecutive sentencing sanction that's possible?
Yes, I think one technically did. However, because only one of them is going to result in a conviction, I don't think consecutive sentencing is an issue.
I would agree, Judge, since the other count's being dismissed, there's nothing for it to run to second to.
All right. And Mr. Eaton, you understand that by pleading guilty to possession of methamphetamine, that the maximum possible penalty for that charge would be up to 10 years and or a $15,000 fine. With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself if you wanted. You understand all those rights. And you understand that you'd be giving up and waiving all of those rights by pleading guilty. So also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of that appeal. Do you understand that? Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said on the record today? Is it your own free choice to enter this plea? Are you pleading guilty because you are actually guilty? Information I have indicates that this happened back on December 18th of 2024. Is that the correct date? On that date, were you present here in Otsego County? While you were here in Otsego County on that date, did you have possession of some methamphetamine? Did you know that that's what that substance was?
I was pretty sure.
Did you believe that that's what that was? Did you have any legal right to have any amount of it at that time? Mr. Rolla, are the people satisfied with the factual basis?
Yes, thank you.
Mr. Church?
And defense is satisfied.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
Good night, thank you.
Mr. Church?
Aware of none, Your Honor.
And Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Church?
And satisfied.
Mr. Eaton, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, it's important that you stay in touch with your attorney, Mr. Trush. Before you leave today, you're going to meet with Ms. Davis from the probation department to set up a pre-sentencing.
Jen,
Yeah.
I'm sorry, can we get an updated address? It looks like we have mail come back.
So we have an address for you on Burdo Road. Is that the correct address?
Oh, we have that.
But
Oh, I'm sorry. Brentwood? Which one?
we, our primary residence is Berto, but it's not, in good shape right now. We're staying temporarily at one of Brentwood.
Is that the one that came back?
I can't tell. You'd have to look.
That
What
was the last notice. That's where it was mailed.
was Brentwood?
Yeah.
Yes, and that's where it came back from, because that's what I have in the computer as well.
So we tried to send mail to the Brentwood address and it got returned. So where should we send it?
The Berto address is better.
Okay.
I don't, you see it in the file though?
Yeah.
Okay, I'll find it and get it put in.
Yeah, it's on the initial complaint.
Okay, so, thank you.
All right, thank you. All right, let's take Mr. Butts is lodged here.
I don't believe he is.
Let's take a short recess. We'll come back on the record at 10 o'clock.
Right.
Thank you, sir. Mr. O'Neill, would be brought up. Okay. Thank you. Sweet, thanks.
For sure, go for it.
Saturday, not so much. No, wait.
Yeah, I found it. I got it. Last Tuesday. For Catholics, you can't eat on Fridays, especially during Good Friday, that would be seriously. Anyway, so I made a ham with a orange, I'm sorry, that's pineapple, tangerine, brown sugar glaze, with of course the fresh pineapples and cherry stuff. And cloves. I made our own family's fresh sausage. I made our smoked sausage. And of course, the other stuff that you have to have, like the egg, the butter lamb, and the wine. In this case, we use marble bread this time. One likes the French bread, and one likes pumpernickel, so I get the marble. I kind of like, yep, I got it covered. So I'll probably make a bunch of rounds then too. So I've got a bunch of sauerkraut that I made. So the extra. All sorts of different things. Melted cheese, Swiss cheese. Fried mustard maybe. Or stone bun mustard. Fried mustard actually that fresh and smoked. So that'll add to the steak. And with the mass for 8 o'clock, mass, and then go back. Brunch started at 9 and finished at 3. It's got to be about 6 points of fresh holes. 4 points is on. Check what's might actually get out there. Instructions on it. So just snack a little bit on other stuff. Kind of some extra sharp cheese. Yeah, so I'm down now to 2 packages of fresh sausage, but I did notice that the food services pork butts on sale for $1.89, and they're the boneless ones. So it's even better price because you're not paying for bone. So I will pick up probably about 75 pounds of that, and then make about 100 pounds of sausage. No, not really. I mean, the first time we did it, I did it, I saw a couple of recipes out about 30 pounds. But then after every people asked for, we had like 5 pounds left. They're all we don't have anything. So then I upped it to 50 pounds, but then word got out and we make it. And so then that was. But we grow our own and I've actually well, it's the same recipe. I just use 2 different variations of one from each other. I use golden leaf as well as sweet chocolate instead of just sweet. It balances better with the other stuff. Cooking every time. It's not chemistry. That's really all it is. I mean, no. Yeah, my dad. Yeah, Mike. He was like, "What did you do different? You can taste this more." I'm going, "Yeah." This is the girl over there. Oh, it must be the pressure. This is all that's one stuff. I'll tell you the other part, but I have to kill you. No, I shared it with him. And he was glad. And the tradition of making that passed on me. Passed on your. We're the only ones in Canada. So they have no objection to picking up. They'll come to the court and take the stuff over. Here, and now it will be 30 years this year. This year, we haven't done Easter baskets. They're not too old. That's what they said. That's what they said. Well, that's what we've done for the last, yeah, that's what we've done for the last 5 years. Instead of canning, they get trail mix and other different things that they have. They went, nah, it's okay. Plus one could make it. She's in Binghamton, yeah, Binghamton, well, Pennsylvania, New York, take your pick. The campus goes over both states. Yeah, I guess they actually technically live in Binghamton, New York. But, all rise.
Thank you. Please be seated. Is Mr. Renelette here? All right, the court calls People versus Daniel Renelette, case number 236505. Mr. Truitt, have you been assigned to that case? I know this is for an arraignment today. Probably not.
No, I don't believe so, although he was a former client. I mean, I was attorney of record on his file.
All right, so for the record, this case was set for 9:15 for an arraignment on an alleged non-technical probation violation. Ms. Davis, you had indicated earlier that you may have had some contact with him. Just state for the record what your information is.
Yes, Your Honor, he did reach out to and sent a text to his supervising agent, Vertical, wanting to let him know that he was on his way to court and he was at the emergency room as soon as ride gets here. Many issues with the bulging and compressed L5 nerve pain.
Do you take any position on how the court should proceed on this case?
I don't personally know him, Your Honor, so.
Oh, it's Agent Brunical.
It is Agent Vertical's. He did indicate though that he is upset that he's still on probation because he was extended due to failure of paying fines and costs.
Okay. If you could just notify Agent Brunical, I'm going to give Mr. Renelette the day here, as the court's required to do, to appear or otherwise notify the court. We don't have any further contact from Mr. Renelette. Mr. Brunical doesn't by the end of the day today. If you can have him prepare a bench warrant for a violation for failure to appear.
Your Honor, just for record purposes, what's the case number for that?
I'm sorry, what's that?
Just for record keeping purposes, what's the case number?
236505. People versus William Butts, file number 246743. Record should reflect that Mr. Butts is present here in the court today. The date time set for sentencing in this matter. This is a sentencing on a misdemeanor assault and battery. Mr. Truth, did you have a chance to go through the pre-sentence report with Mr. Butts?
We did have an opportunity to discuss it. Yes.
And Mr. Butts, did you have an adequate opportunity to go through that with Mr. Truth?
Yes, sir.
Truth, are there any corrections that need to be made to that report?
No, Your Honor.
Mr. Rolla, do the people have any corrections?
No, Your Honor, thank you.
Do you have any victims that wish to address the court today?
We do not. Thank you.
Anything on behalf of the people for allocation?
No, Your Honor.
Your Honor, first, I would indicate Mr. Butts had some car trouble. That's why he was late getting here today. All things considered, I think the recommendation here is appropriate and reasonable. I say that knowing full well we have a sentencing later this afternoon in Crawford County, which frankly is likely to assume this. So I would suggest to the court the recommendation here is appropriate.
Mr. Butts, anything that you would like to say on this case?
It's gonna sound really silly. My kid's mother has car problems, my girlfriend, whatever. Is there any way of maybe prolonging until the grading sentence day to try and fix the car?
Yeah, I mean,
I'm not gonna run, I take full responsibility for my actions. I called 17 times. The ladies up front was trying to get me to, I just wanna make sure she and the kids are set. I know I'm going to jail, sir. I mean, I just want to make sure they are.
yeah, I mean, it was my intention. I'm obviously aware that we have that hearing this afternoon. This case is going to run concurrent to that one. So I was going to impose a sentence here and have you report to the court this afternoon.
Thank you so much.
Aside from that, is there anything that you want to say?
I don't know if work camp's available. I do have a steady job. I've had it for the last 8 months. I have no problem paying whatever the things are. If that's available too. However, I don't know. I'm here to accept what I have to move forward, to really go about what I was doing.
First of all, I did read through the report. You've been in court with me a number of times on a lot of different matters, so family court matters and criminal matters, so I'm fully aware of your background and your circumstances, as well as information about this incident here in this report. We're going to be talking later today. This incident seems like something that's completely unnecessary, probably something that you wouldn't have done had you not been under the influence. Which was one of the goals of our probation, was sober, because you just get in your own way. You start using substances and you do things that are
Totally.
just counterproductive in so many ways. Every time you seem to get on the right track, you kind of relapse and then you fall back into bad conduct again. And I think that's certainly the case here. I do think the recommendation is appropriate given your past history, given what happened in this case. I think 93 days is an appropriate sentence. It punishes you for your conduct here and is, as a misdemeanor, it's the maximum, but I think at this point, that's kind of where you're at. So the court is going to impose 93 days in the Otsego County Jail. You do have credit for 3 days served. Crime victims assessment, the amount of $75, court costs of $325, attorney fees of $350, $50 state costs. You do have the ability to seek an appeal of this sentence. If you wanted to appeal it, you would need to file for that appeal within the next 21 days. If you have questions about that, Mr. Church would be able to explain that to you. As I said, the court's not going to order you to report to the Otsego County Jail this morning because we do have another sentencing railing this afternoon. that sentence is likely to run concurrent to this one. I don't know whether you're gonna be serving in Crawford County or here, or what the circumstances are gonna call for. So in terms of the work camp, I don't know that, Crawford County doesn't have that. I don't know if that's something, I think it's likely you're gonna be doing your time there as opposed to here, but
That's fine.
we need to have that hearing this afternoon. I don't know what the prosecutor is gonna advocate for, so. But that's the sentence here. You're not gonna be required to report again this morning to the Otsego County Jail. That'll be determined by your sentencing this afternoon. Mr. Rolla, anything further?
No, Judge, thank you.
Mr. Church?
So just so I have a clear understanding, so I know the next steps I need to take, the court's not taking a position on work camp at this time.
Correct.
Understood.
Right, thank you. People versus O'Neill, case number 246759.
Thank you, Your Honor. Richard Trish on behalf of Mr. O'Neill.
Record should reflect Mr. O'Neill's present here in the court today. I did have an opportunity to review the pre-sentence report prior to the hearing. I did also receive a number of letters on behalf of Mr. O'Neill. Chance to review all of those letters prior to the hearing date today. Although I didn't get the PSI till this morning, I did get those letters prior to the weekend, so I had a chance to review all of those. Mr. O'Neill, did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that?
I did.
Okay. Mr. Trush, are there any additions, deletions, or corrections that need to be made to that?
Your Honor, I would indicate, I did have an opportunity to talk to Mr. O'Neill. He indicates to me, and I'm going to directly point the court to description of offense narrative. He indicates to me that he was not trying to destroy any of the evidence at the time of the offense. Again, given the narrative situation and that he has his opportunity to tell his version of the narrative as well, I don't know it rises to the level of a correction, but I did want to identify that for the court.
And yeah, Mr. O'Neill, you can tell me more about that if you want in a moment. Any other additions, deletions, or corrections, Mr. Church?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rowland, do people have any additions, deletions, or corrections? Any challenges to the scoring?
No, Judge.
Anything on behalf of the people for allocation today?
Judge, in this particular case, this is the first felony, but a second controlled substance situation. It's a recommendation of probation 1 year with 9 months held in advance. As the defendant previously had a use of cocaine in 2024, people would respectfully suggest that that would send wrong information, wrong message to the public. We think that perhaps probation of 2 years to make sure he doesn't continue to use is more appropriate, and the court should seriously actually consider imposing some jail time. Thank you, Judge.
Thank you, Mr. Church.
Thank you, Your Honor. This is a wholly unique situation, I think. Yeah, Mr. O'Neill, I think, is going to tell you that this is about escapism. I think you can look at his record and see there's not really any significant prior history until he has this traumatic event. He has some significant health issues that he's diagnosed with, and if the court looks at his life prior to that, I think as the letters reflect, he's an upstanding citizen. And he's someone who does the things we want to see people doing in the community. He elevates the people around him. And he's instrumental in the letters you reviewed, being instrumental in helping other people chase their dreams. There's really no nobler endeavor to engage in. He gets this tragic news that he is incredibly ill. He has leukemia, and I'm sorry, I'm not gonna get right the other issue that he has, or I'm sure he'll explain to you. But he has these two traumatic things going on, and He turned to substances to escape it. And I'm not gonna say it's right, but I certainly can understand how it could happen. You know, he's young to be staring down terminal illness. And it's not right, but it's what happened. He chose to escape, to go to a different place. And I think he recognizes now that that's not the right decision. And it's not the right decision because he wants to embrace and enjoy what time he has left, and escaping isn't doing it. And escaping is just going to a different place. I think that if he does have supervision, the imposition of jail isn't necessary. I think he'll do well with the supervision. So I think the recommendation here actually is very appropriate. I think it takes into account what happened here with what his prior history is and with his very unique circumstances. I mean, this is a situation, Your Honor got a letter from the jail nurse about the significance of his health issues. And frankly, this is the first time I've ever seen the jail staff really step in and say, hey, he's got some significant issues that will present a challenge. So again, all those things taken into account, I think the recommendation here is appropriate. Thank you.
Thank you, Mr. O'Neill. Anything that you wanted to say?
One to do with that letter. Last week when it was written, was me finding out that I'm not in remission anymore. Meaning and stating that 5 years, which is on the very optimistic side of my life expectancy, it's now dwindled down to a medium of probably less than a year. I don't know if you know much about leukemia. There's a 20% chance of survival, 3 or 4 people die from it. I did survive the first round of it. My oncologist will say that I'm 1 of 2 miracles that he actually considers it in his medical history, because there's no scientific reason why I am alive. Outside of that, I brought in a letter to the court too, and I'd like to read that if that happens. To make concern, not to convey does not excuse privilege, justify nor overshadow my actions this year. It's my personal one of grand dismay and unequivocal loss. Loss that I find myself accountable, squandering my finite time left trying to find that lift my head from the shame and actions that I placed upon my own shoulders, weighing myself down. I realize that just because I can does not grant me the right to, or that I should. And remorse for the edifice of life's rapture is bestowed upon myself, and I find myself seeking escape from the traumas of life that I have endured, things that are beyond the reasonable realm of man. I stand here for the better fortitude of my own monostoical actions, no longer negating school time frames and aware of the gravity of my own undoing, and very well might damn myself to spending my fleeting timeline in purgatory in my own personal life sentence, trading my monetary distractions from the weight I personally bear, dealing with loved ones' mental illnesses on several attempts to execute their own life and battling their own mental illness, and sadly being witness to the regards of having to resurrect them, I said loved ones and myself on various occasions, while still being haunted by the images of that in my mind, and still antagonized by the gloomy aspects of my own mortality as well. The harsh, relentless, ongoing battle facing the acute plastic leukemia for the last few years, recently finding out that I'm no longer in remission. I'm burdened by the realization, grasping the reality of my terminal prognosis, not only from that, but also from my Mycobacterium avium complex, which is a fungal infection slowly spreading across my lungs and growing like a microcelium. After 2 years of unsuccessful intravenous treatment, now leaving me counting my days, my weeks, and hopefully months. Weighing my many moments. How many moments? What wisdom or legacy I have left to share, and how long do I have before my body can no longer withstand that life that I wish to live? Those moments now with the opportunity to give meaning to. Here, I risk trading my precious, unmeasurable moments, memories, and self-pity. I lost sight of what was truly important in this world, the monumental, seemingly minuscule sunrises and sunsets that we all share and take for granted. Spending the last few weeks in the county correctional facility has made me very aware of what's at stake, what's important, what I've lost, and what I've taken advantage of. And I find myself humbled by the court's mercy, seeking redemption, understanding more now than ever that tomorrow is full promise, however, it is not promised. And it makes me recall a quote from Ben Chaplin that says, "A drowning man is not a dying man until he's had his last breath."
All right, thank you. Mr. O'Neill, I did read through the report, so I'm familiar with the information in there, what brings you before the court here today. Like I said, I read through all the letters, including letter from the jail nurse regarding your health condition. And looking at your prior history, which is minimal, the letters, which were very complimentary of you, I don't see many people have that many individuals willing to write letters on their behalf come through here. So that says something to me as well. And of course, your health condition is consideration, although not as important as some of the other considerations, although I am sorry to hear about your condition. Certainly not news that you wanted to get, I'm sure.
That piece of paper in here.
Yeah. So, all of that combined, and the fact that you've served 37 days, which I think is a fair penalty given your health condition. I don't see the need to impose any additional jail time and to give you an opportunity to avoid that through probation. I hope that you are motivated to do that, because to the extent that your conditions are going to shorten your life significantly, the last thing you want to do is spend that time in jail. So I am going to adopt the recommendation to the extent that it does not impose any additional jail time. The court's going to hold that time in abeyance, so that if you do comply with your probation, you won't ever have to serve that time. If you reoffend or have issues on probation, the message that that's going to send is that the other considerations aren't as important, and at that point jail time is going to be warranted. So I hope that you follow through. I hope that you do comply with the probation, and I hope that your health condition improves. So the court is going to adopt the recommendation. The court is going to send you to probation for a period of 1 year. The court's going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court's going to impose the 9 months of jail, but I'm going to hold that time in advance again, as I indicated. You have credit for 37 days served. The court is going to order that you pay court costs of $325, attorney fees of $350, $60 DNA testing fee, and a $68 state cost. Also, while you're on probation, supervision fee of $30 per month. You do have the ability to seek an appeal of the sentence, and Mr. Church, have Mr. O'Neill acknowledge receipt of those.
I will, Your Honor. I would suggest to the court, this may be a case where waiving the court-appointed attorney fee is appropriate.
People would have no objection to that, Judge.
Okay, then I will waive those.
Judge, did you want to order the crime victims of 130?
Yes,
I must have missed it.
$130.
Okay. Thank you.
Good luck to you going forward, Mr. O'Neill. People versus Damian George, case number 256789.
Thank you, Your Honor. Richard Church, on behalf of Mr. George.
We have Mr. George present here in the courtroom today. This is the date and time set for sentencing. Mr. George, did you have a chance to review the pre-sentence report and go through that with your attorney?
Yes, Your Honor.
Do we have any additions, deletions, or corrections?
No, Your Honor.
Challenges to the scoring?
No, Your Honor.
Any additions, deletions, or corrections?
Your Honor.
Any challenges to the scoring? No. Anything on behalf of the people for allocation?
Judge, is this all the firearm along with one of the motor vehicle would ask that the firearm be confiscated and condemned for statute?
Church.
Thank you, Your Honor. Frankly, I suspect the firearm's already under a confiscation order. This is a situation, well, Mr. George presents to the court here with fairly minimal prior history, a handful of misdemeanors. This is, his first foray into the circuit court, so to speak. This is a situation where in some ways, I think, unfortunately, Mr. George is somewhat of a victim here himself. He had a person who he thought was a friend of his, who is not a friend of his. That person wanted to borrow his firearm. That person was not entitled to have a firearm. Mr. George knew that person had some felony history. Mr. George chose to let that person borrow that firearm. It's not a good idea. And that person chose to use that firearm in a significant crime. This is a circumstance that I think is eye-opening to Mr. George. He recognizes, I think, that the people he surrounds himself with can get him in trouble. I think he recognizes that the person who he loaned that gun to is not his friend, right? And at the end of the day, the things that he did, that other person did, result in him getting in trouble. And that's not what friends do to you. I don't think that jail is required here for him to get that message. I think that this is really more a crime of not thinking things through very well than a crime of malice. There's nothing to suggest that Mr. George had any idea what the other person was going to do, or that he wanted that person to commit those crimes. I think this is really just an extreme case of poor judgment, really all around by Mr. George. I do think the recommendation here is appropriate. I think that a lengthier probation term is a good idea to help him to make better choices. I think that imposing jail up front is not necessary here. I think holding it in abeyance is a better response, not only because this is a first felony situation, but just the circumstances here, I think, can only lead to a conclusion that Mr. George is far less culpable than the other party here. While not completely absolved of wrongdoing, again, I think obviously the less culpable person. So I would suggest that the recommendation here is appropriate.
All right, thank you. Mr. George, anything you wanted to say today?
I just wanted to say that, like Mr. Chu said, it did open my eyes. Basically, it was bad judgment on my end, and sitting here in front of y'all today, it definitely don't plan on having it happen again. Pretty sure I probably won't get my gun rights back, but even if I do in the future, that's something that if it's licensed to me, it's staying in my property. I'm not taking the risk. I learned my lesson. So I just want to say that, I do accept that I was in the wrong and it was a lesson learned.
I did read through the report. I'm familiar with your circumstances. I'm familiar with what happened in this case. And, I agree with counsel. There's nothing in this report that indicates to me that you're a violent person, that you're a danger to the community in some way. I think what this is a failure to appreciate the responsibility that gun ownership brings. And there's a reason why there's a law against people with felonies possessing firearms. That's because people who have shown that they're willing to commit felonies are usually willing to do dangerous things with firearms. And so your decision to give that person access to that, and I'm familiar with today, and he's not somebody that we want having possession of firearms in our community. And if you didn't know that, you should have known that about him. And the last person you want to give access to a gun is that individual. And so I do think there's some culpability on your part here, because I think, again, you have a responsibility as a gun owner to take care of that weapon and to make sure that it's not used in an inappropriate way. And you put the wheels in motion for that to happen, even though things didn't in this case. So I think, probation is the correct way to deal with this. That's going to give you an opportunity, number one, to avoid any kind of jail time. And I don't think upfront jail is appropriate. There aren't any factors here that convince me that that's necessary at this time. I think holding it in abeyance is important because it's going to provide hopefully some motivation for you to comply with your probation. And it's going to provide a penalty if you don't. And one that the court can impose immediately. So the court is going to put you on probation for a period of 2 years. You're going to adopt as the conditions of that probation, all the terms and conditions listed in this report. And the court is going to impose 90 days in jail. I'm going to hold that in abeyance. So if you comply with your probation, you won't have to serve that time. If you have problems on probation, then I can impose any or all of that immediately. You do have credit for 2 days served. Court will impose $130 crime victims assessment, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost, along with $30 per month fee for supervision while you're on probation. The court will also order forfeiture of the weapon involved. You do have the ability to seek an appeal of the sentence, and Mr. Trush and Mr. Jordan acknowledge receipt of this appellate rates. So you've received his appellate rights.
He has, Your Honor.
Thank you. That's all for today, Mr. George. Good luck to you. We're getting Mr. Evans' motion set for 10:30. I don't see anybody signing in for.
I haven't had communications from defense counsel since that was filed on our office last week. I do know too, as well, my office manager pointed out to me that she attempted to send it to, we mailed it hard mail, but we also attempted to send it electronically email. The email address in the bar journal as set forth through state appellate defender's office, Mr. Ibret, and it came back with an inaccurate address, which I don't understand. That was pointed out to this one.
Okay, so for the record, this motion, this is People versus Jason Evans, file number 236554. This motion was filed by the State Appellate Defender's Office through Mr. Eggert, the attorney, on March 3rd. It's set for hearing on today's date at 10:30. It's now 10:36. I don't see anybody from the Appellate Defender's Office appearing. It was set by Zoom. Mr. Rolla is present here in the courtroom. Given the lack of counsel hearing today, counsel for the defendant, the court's going to deny the motion without prejudice. If the defendant wants to refile the motion and reset it for hearing, they can. They did provide a proposed order, so Mr. Roll, I'm just going to write in that order the action that the court took today, so you don't need to prepare an order in this case.
Very good. And the court did receive the people's response with exhibits in regards to the motion. Correct?
Yes.
Should this be refiled, we just ask the court to take the same arguments into consideration and deny the motion should it be brought to our attention.
Okay, thank you. Next hearing is set by Zoom at 10:45. Be in recess. Okay, looks like we have council connected. We'll go on the record in Trevor versus Northern Food Group, file number 2319554. If I could have council put your appearances on.
Good morning, Judge Elliott Blumberg on behalf of the plaintiff. Good
morning, Paul Slough on behalf of Defendants Northern Food Group, Joseph Anzinick and Dominic Bonnell.
All right, we're on the record here today on defendant's motion to compel. Mr. Slough, how did you want to proceed with that today?
I'd like to proceed with the motion, if I may.
Okay. I did have a chance to review your motion. Is there anything you wanted to state for the record in support of that?
Yeah, just real briefly, Judge. So I think the court knows that this is a lawsuit involving the local Jersey Mike's franchise. Plaintiff was an investor. He was removed for violating the operating agreement. The court's already ruled on that removal, that it was proper. The remaining questions are really twofold. One is, what is the amount that my clients have to pay plaintiff, if anything, for his interest in the limited liability company? And we've produced a valuation consistent with what the operating agreement requires. My understanding is plaintiff has an expert working on evaluation. The second issue is there's an allegation that there was a misuse of a company credit card that caused damage to plaintiff. We served out these discovery requests in January. We requested a copy of the valuation report. We've requested more detailed information on the alleged fraudulent credit card use. We've never seen any evidence with regard to the credit card fraud allegation. Nothing attached to the complaint. There's been no initial disclosures serving us with any supporting documents. So on the first question, which I think is the easier one to deal with today, the valuation report evidently is pending. Please fix a deadline. And I would suggest June 2nd, which is the next status conference. We need some accountability to make sure that that gets done. It's now been not just over a year since the case has been filed, but it's been over a year since my clients produced a valuation report. We just have to follow the operating agreement. So there isn't a hard deadline set in the operating agreement, but I think a year is more than enough time. Let's please have some accountability and fix a deadline. On the credit card claims, this is plaintiff's case. I mean, he filed this claim. We originally responded with a motion for more definite statement because the allegations about the credit card use were so vague. The amended complaint at least identifies which credit card we're talking about. But again, there's been no production of any statements, receipts, invoices, no evidence of any damage to plaintiff. It's now been over a year since the case has been filed, and we still don't even know which claim exactly we're defending. We don't know what transaction, how much, who, when these transactions happened. So please consider dismissing those claims. I think it's a perfectly appropriate remedy under the circumstances. Alternatively, we'd ask for $600 for the cost of bringing this motion and set a deadline, say 30 days or June 2nd would be perfectly adequate to provide responses, detailed responses to those discovery requests. And then we can file a summary disposition motion and go from there. Thank you.
All right. And I think this is, I can assume this based on your argument, but both of those issues are the subject of your discovery requests that were submitted on January.
Yeah, that's correct. As I probably didn't make clear enough, the discovery requests primarily focus on asking questions about this alleged credit card use that was, again, allegedly fraudulent. We did also ask them to produce the valuation report or any valuation information they have at all about the company in their possession. And I know Mr. Blumberg's indicated to me both on the record at the last hearing and just recently informally that they are working on that. And I believe him. But again, it's frustrating for my clients. They're trying to run a business. They got a valuation report done. It's been over a year now since that's happened. We just want some accountability to make sure this is going to get wrapped up.
All right. Thank you, Mr. Blumberg.
Well, Judge, clearly Mr. Trevor has brought this action because we believe he was wrongfully discharged from the franchise, Jersey Mike's. The court has ruled on that. The operating agreement certainly requires him to produce a business valuation, which he is in the process of doing. Again, this has left him without any income. He's had to pay Atomy Valuation out of Grand Rapids $10,000 to take on this project, which they have done. We have a meeting with them later this week. Hopefully, by the end of the week, we will have at least a preliminary finding as to the valuation. But again, all of the documents were in the possession of the defendants, and Atomy has attempted to get things directly from them, and they've not been given everything that they need. We will have a preliminary report probably within 14 days at the latest. And again, once that report is submitted to the court pursuant to the operating agreement, if the parties can't come to an agreement as to the two reports, then a third report has to be prepared. So while this has taken a while, it's going to take even longer unless the parties can come to some type of agreement. Now, let me address the other discovery request. Joseph Trevor has been in and out of a hospital for the last 2 months. I have unsigned interrogatory answers that I can provide Mr. Slough. That doesn't mean that they're signed, and the court rules require a signature by Mr. Trevor. I have not been able to get his signature on those, but I will have signed answers by the end of this week, one way or the other. If I have to go to Munson and Traverse City to get his signature, then that's what I'll do. But asking for a dismissal at this point, I think would be piling on and totally inappropriate. If Mr. Slough needs $600 to get these answers from me, I'll write him a check. The fact of the matter is I can't give him the information without my client's participation.
Okay, all right. So first of all, the court finds that Mr. Slough's clients are entitled to the discovery that they're requesting. So with regard to the valuation, the court, I agree in a preliminary finding is one thing. I agree that given the amount of time that's passed, that June 1st for a final report is a reasonable time frame, given that where we're at now, that's about 6 weeks. So the court is going to order that Mr. Trevor provide a valuation report by June 1st. The court is going to order that the other discovery regarding the credit card information be provided within the next 30 days. In terms of a sanction at this point, I reviewed the court rules. They're pretty clear that sanctions are not appropriate until the party has violated an order to compelling discovery. So at this point, the court finds that it doesn't have a basis to award any sanctions and certainly not a dismissal. However, to the extent that either of those are not provided within that period of time, and Mr. Blumberg, I understand that may not be outside of your control, you can only do what you can do, but your client is going to be proceeding at his own peril to the extent that he doesn't assist you in doing what you need to do to comply with the court's timelines. So at that point, if those aren't produced by those two timeframes, then Mr. Slough, I think you may be entitled to sanctions at that point. The court will have to determine what, if any, are appropriate. But for now, the court is going to grant the motion to the extent that, again, the valuation be provided by June 1st, that the outstanding discovery requests regarding credit cards be provided within the 30-day time frame. And Mr. Slough, you can prepare an order that reflects that ruling of the court today.
Yeah, I will prepare an order. And I would ask too that Mr. Blumberg, if the expert you've retained needs documents, please have them contact me if they're not getting them from my client. I mean, I'll help facilitate that. I had not heard that there was any issue, but we'll work through those issues. I just hadn't heard that there was such an issue to talk about.
Very good. Thank you.
All right. Thank you,
Okay,
Judge.
thank you. That's all for this hearing today, and you're both free to disconnect. Okay. Ms. Webb, are you able to hear me okay?
Yes.
And Mr. Webb, are you able to hear me?
Yes.
Okay, thank you. We're on the record now. This is Webb versus Webb. This is file number 2419886. The record should reflect both parties are present today by Zoom video. I have this set for entry of a final judgment of divorce today. Ms. Webb, is that how you wanted to proceed as well?
Yes, Your Honor.
And Mr. Webb, is that how you wanted to proceed?
Yes, Your Honor.
Okay. I'm going to ask you both to raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Yes, Your Honor.
Thank you. You can both lower your hands. I'm going to be asking each of you a series of questions. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Webb, as the filing party, most of the questions will be for you at the beginning here. Ms. Webb, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes, Your Honor.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, Your Honor.
Had you been a resident of Otsego County for at least 10 days?
Yes, Your Honor.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes, Your Honor.
Does that remain true today?
Yes, Your Honor.
All right, and there are 2 children under the age of 18 that were born of the marriage, is that correct?
Yes.
And under the proposed judgment of divorce, you and Mr. Webb would share joint legal and physical custody of the children. Is that your understanding?
Yes.
And is that arrangement, in your view, in the best interest of your children?
Yes, Your Honor.
Okay. And then in terms of parenting time for each other, you guys, you're going to agree on how that's going to work. The court's not going to order any specific time. Is that your understanding as well?
Yes.
And again, do you believe that that arrangement is in the best interest of your children?
Yes.
Okay. As part of the judgment, Ms. Webb, you are not going to be receiving any spousal support or alimony. You understand that?
Yes, Your Honor.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
Are you currently pregnant?
No, Your Honor.
Okay. And this proposed judgment indicates that you and Mr. Webb have already divided up all the property of the marriage and there doesn't remain any issues for the court to decide. Is that correct?
Yes, Your Honor.
And that you don't own any real estate or real property together?
Correct, Your Honor.
Okay. And are you asking to have your last name changed?
No, Your Honor.
All right, thank you. Mr. Webb, did you hear all the questions that I asked Ms. Webb?
Yes, Your Honor.
Were you able to hear all of her answers?
Yes, Your Honor.
Do you have any reason to believe that any of the answers that she gave were untrue?
I do not, Your Honor.
And with regard to the children, you understand that you and Ms. Webb will share joint physical and legal custody and that parenting time for each of you will be as the 2 of you agree. Is that your understanding?
Yes, Your Honor.
And as the father, do you agree that that would be in your children's best interest?
Yes, Your Honor.
Mr. Webb, you understand that you will not be receiving any alimony or spousal support either. Is that correct?
Yes, Your Honor.
You understand that you also will be waiving that forever and that you could not come back later and ask the court for that?
Yes, Your Honor.
And do you agree that you and Ms. Webb have divided up all the assets and debts of the marriage and that there remains nothing for the court to decide?
Yes, Your Honor.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The Court's reviewed the proposed judgment, finds that it's equitable and contains all the provisions required by statute. The Court will sign that judgment with today's date. Ms. Webb, do you have any questions at all?
No, Your Honor.
Mr. Webb, do you have any questions?
I do not, Your Honor.
Okay, thank you. That's all for today. Your divorce is now final. Both of you are free to disconnect at this time.
Thank you.
Thank you. Have a great day.
Johnson.
Hello?
Hi, sir, are you Richard Johnson?
Yes, I am.
Okay, we'll go on the record. This is Johnson versus Johnson. This is file number 2519973. The record should reflect that Mr. Johnson is present today by Zoom video. Mr. Johnson, I have this set for entry of a default judgment of divorce today. Is that how you wanted to proceed?
Yes, Your Honor.
Okay. So, Mr. Johnson, you filed a complaint for divorce that was properly served on Ms. Johnson. She failed to file any answer to that. Then this was set for a default judgment hearing today. She was provided notice of the date and time of today's hearing, which was 11 o'clock. It's now 11:15. She has failed to appear. So we can proceed with the default judgment. Mr. Johnson, I'm going to ask you to raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Johnson, I'm going to be asking you a series of questions. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. My first question is, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes, Your Honor.
At the time that you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Yes, Your Honor.
Had you been a resident of Otsego County for at least 10 days?
Yes, Your Honor.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes, it still is.
Okay, that's my next question. Does that remain true today?
Yes.
Okay. Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, Your Honor.
To your knowledge, is Miss Johnson currently pregnant?
No, Your Honor.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, Your Honor. I know it's.
Okay. And the proposed judgment indicates that you and Miss Johnson have already divided up any assets or debts of the marriage. Is that correct?
Yes.
And you don't own any real estate or real property together. Is that true?
That is true.
Okay. Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of Mr. Johnson. The court has reviewed the judgment and it contains all the provisions required by statute. Again, the court, for the reasons I stated at the beginning, finds that a default judgment is appropriate. The court will grant the divorce. I've signed that judgment with today's date, so your divorce is now final. Mr. Johnson, did you have any questions at all?
No, thank you, Your Honor.
Okay, thank you. That's all for this hearing today, and you're free to disconnect at this time.
All right, you guys have a good day.
Thank you. Okay, looks like we've got the parties connected on Turner versus Turner. This is file number 2419678. Mr. Blumberg, do you have Ms. Turner in your office there?
Yes, I do, Judge. She's appearing via Zoom from my office.
All right, thank you. And then Mr. Turner is appearing on his own behalf by Zoom as well. This is set for a status conference today. I know there's, just looking at the file, it appears there's some issues that are currently set for hearing in front of the referee. But in terms of property and moving forward with that portion, Mr. Blumberg, can you give me a status there?
I think I can, Judge. Actually, I was under the impression that the parties have resolved all of the issues. One of the remaining issues is Mr. Turner is yet to participate in the SMILE program. I think that's an issue that needs to be resolved before a judgment can be entered. But I sent him an email this morning asking him to confirm what I was led to believe there was an agreement on all the issues. And if that's the case, I can have a judgment prepared as soon as the SMILE program requirement is met.
Okay, and that may be the case. I'm just looking at what's in the file. Mr. Turner, can you speak to that?
Yeah, I can agree that me and Mrs. Turner have come to an agreement on all issues. As far as the SMILE program is concerned, I was registered for the one this month, but because of the ice storm, it was canceled. I re-registered for the next one, which is May 5th. So after May 5th, I believe we should be good to move forward.
Okay. All right, so Mr. Blumberg, unless you have an objection, I'll just set this for a final hearing date following sometime subsequent to May 5th, and then we can take proofs and get the judgment signed. Do you have any objection to that?
No, I will certainly have a judgment prepared in anticipation of that.
Okay. Mr. Turner, does that sound like a plan?
Yeah, that sounds.
Okay. All right, so the court will send out notice of the date and time of that final hearing, and we'll go from there. All parties on this file are free to disconnect at this time.
Thank you.
Hi, whoever's joining us with the phone number, last four digits, 2814. Can you tell me your name, please?
Ty Gatewood Cotton.
Okay, thank you. One moment. All right, looks like we have everybody connected, so we'll go on the record in Cotton versus Cotton. This is file number 2319201. We have Ms. Dukes McCoy with the plaintiff connected by Zoom video. Ms. Komorowski is connected by Zoom video, and we have Mr. Cotton also connected. This is set for a status conference today. Ms. Dukes McCoy, on behalf of your client, can you tell me where things are at with this file?
Well, we have everything almost resolved, Your Honor. There was a child support recommendation that was done by the friend of the court. The last day for the objection was last Monday, and then Ms. Komorowski had filed an objection. So we still have child support outstanding. I do not know when the hearing date on that child support objection is going to be, but I have updated the judgment of divorce that we had done before. I haven't sent that over to Ms. Komorowski yet, but to reflect the parties' now their the court's orders as well as their agreements from before. So we're prepared to enter that as soon as we get the final recommendation from the front of the court.
Okay, on the child support issue?
Yes.
Okay. Ms. Komorowski?
Accurate.
I'm sorry.
Your Honor, can you hear me?
I can now, yep. You were delayed there at the beginning.
Okay. Ms. Dukes-McCoy is correct. That sounds accurate to me.
Okay, do you know, have you got a date yet for a hearing on the child support?
I have not, Your Honor. The friend of the court's office said that they wanted to set it for a date instead of giving me a date to send a notice of hearing out. So I don't have a date.
Okay. All right. I'm going to set this then for a potential entry of a judgment. I'm going to set it in 30 days. If for some reason that hasn't been resolved by that point, if counsel can just notify the court and we can take that down and then reset it once that issue is addressed. But I'd like to at least get it on the calendar for next month so that if it is addressed, we have a date out there and we can get things cleared up. Do you have any objection to that, Ms. Dukes-McCoy?
No, I think that's wise, Your Honor. I did have a question. If we did need additional time, would we just be able to email Ms. O'Rourke, or would the court require a stipulation?
No, if it's because a friend of the court didn't get it scheduled, then I think if you could just notify the court and Jennifer can confirm that through FOC and then we can move it.
Okay, thank you.
Ms. Komorowski, anything further from your side?
Nothing further, Your Honor.
Okay, thank you. That's all for this hearing today, and you're both free to disconnect at this time.
Thank you.
All right, we also had a hearing at 11:30 for entry of default judgment of divorce. I'm sorry, a default judgment, not of divorce. That is in Vanderbilt Real Estate LLC versus Property Partners LLC, file number 2419955. Again, hearing that was set for 11:30. It's now 11:40. No parties have appeared on that. Court will reset this for another hearing in 30 days. Neither party appears at that time. The court will dismiss the case. That concludes our morning docket.